In a dramatic legal showdown, a new lawyer battles fiercely to bar their client's former attorney from the case after the ex-lawyer's shocking defection to the district attorney's office, igniting conflict of interest fears. Will the former lawyer expose valuable secrets, spilling confidential client details to sway the prosecution? This video dives into the heated arguments, ethical quagmires, and cunning courtroom tactics as loyalty and justice collide. With stakes sky high and trust scattered, don't miss this electrifying case that could unravel everything.
Your Honor, this is my motion asking for disqualification of the District Attorney's Office from prosecuting this case against the defendant, Mr. Gregory Hansard. The basis for it, Your Honor, is that Mr. Hansard has been represented by the Public Defender's Office since November 2023. And at that point, he began to be represented by Mr. John Stevens, who in around a year later, after November 2023, he joined the after representing the defendant for approximately a year, he joined the district attorney's office and became the DUI prosecutor there. He's not involved in he's not chiefly primarily handling the case against Mr. Hansard, which would obviously be a problem, but instead, rather, he's a member of that office now, and Mr. Hansard has legitimate concerns about confidential information that was acquired by Mr. Stevens in the course of representing him that is now at risk, Your Honor, of disclosure to General Stevens' colleagues. And our argument is that that creates too great a risk to Mr. Hansard's constitutional right to have a fair and impartial trial in this case, and that requires recusal of the district attorney's office entirely and appointment of a district attorney pro tem to prosecute this case. My plan for this, Your Honor, would be to briefly put on Mr. Hansard to testify to the fact of his prior representation by General Stevens, and that he provided that information in the context of an ordinary criminal defense representation. And then from that point, the burden shifts, Your Honor, to the district attorney's office to show, if they can, that there have been measures taken that would reduce the risk to the defendant to an acceptable level. So that was what I anticipated from this.
All right. Let me hear from the state first, and then I'll let you put your proof on.
Your Honor, I've read the council's motion and as well as their memo in support of it, and agree with a lot of the things that are in there, and that the office, the state is also to abide by all of the same ethical responsibilities, and we have done so. So once the Public Defender's Office puts on their proof, we can call and put the different things that have gone into place to show that we have abided by the ethical obligations and that there has been no mixing of information that would release confidential information that he had disclosed to his prior counsel.
All right. And you may call your first witness. Answer if you'll come around here, please.
Mr. Hansard, please state your name.
Gregory Hansard.
Now, was John Stevens your lawyer at the Public Defender's Office?
Yes.
When did he begin representing you?
He was assigned to me literally my first day of court, honestly. I can't remember exactly what date that is.
Was it in late 2023?
Yes.
And did you talk to Mr. Stevens on the phone?
Yes, talked to him on the phone, talked to him with meetings in the office, and we just went from there.
You met with him in the office a number of times?
Yes, sir.
Do you know about how many times you met with him in the office?
Probably like 7 to 8 times, honestly.
How many?
7 to 8.
No. During those meetings, and I'm not going to ask you for the content of what was discussed, okay? So just answer what I'm asking. Did you discuss the case with Mr. Stevens?
Yes, sir.
Okay. And did you talk about the allegations against you with Mr. Stevens?
Yes, sir.
Did you tell him his side, your side of the story, so to speak?
Yes, sir.
Okay. And did he discuss with you any plea offers?
Yes, sir.
Okay. And you expressed your response to those plea offers?
Yes, sir.
Okay. And then did you talk about potential witnesses?
Yes, sir.
Okay. And did you discuss case strategy?
Yes, sir.
Do you believe that in the things you discussed, there are things that you would not want the prosecutor's office to know?
Most
given that they're
definitely, yes, sir.
prosecuting your case?
Yes, sir.
Okay. Do you have a concern about Mr. Stevens continuing to play a role or be a part of the prosecutor's office?
Yes, sir.
Do you believe that you can have a fair trial if Mr. Stevens is,
No, sir.
if the DA's office continues to prosecute you in this case?
No, sir.
I'll pass the witness, Your Honor. Thank you.
Any questions? Thank you, sir. You may step down. Bob, do you have any other witnesses? State wish to put on any proof?
I'd like to call John Stevens, please.
Stevens, come around.
I swear from testimony given in this truth, nothing but the truth.
I do.
Right. Mr. Stevens, can you state your name?
John Stevens, spelled Stephens.
And Mr. Stevens, where are you currently employed?
With the 23rd Judicial District District Attorney's Office,
And when did you start that employment?
December 1st, 2024.
And previously you were employed at the Public Defender's Office in the 23rd Judicial District?
I was for about a year and a half.
A year and a half, okay. So upon being employed at the 23rd Judicial District, what process did you go through in disclosing cases that you had been assigned to at the Public Defender's Office?
General Crouch met with me and said, what all cases do you have that could be going forward with trial? I gave him all of the cases that were still pending, including Mr. Hansard's, to notify him that that was one that I needed to be screened out from for ethical reasons.
Okay, so you said the word screened out. What do you mean by that?
General Crouch wanted to make sure that any of the cases that I had that were still pending, that he would do an appropriate process of notifying everyone in the office. In Mr. Hansard's case specifically, I recall him sending out a mass email to remind everyone in the office not to discuss this case with me in any way. All the files any files relating to these cases, this is not a DUI file, but any cases that were still pending, he would have the files moved to somewhere else. That way I could not access them. And ultimately, we were not to discuss the case in any way, shape, or form when we were around each other.
And were some of those cases in fact given to other attorneys in pro tems and things like that?
To my knowledge, yes.
Okay. Right. So has anyone asked you any questions about Mr. Hansard's case?
They have not.
Okay. Do you have any access to that file?
I do not.
I have no other questions, Your Honor.
Albert, do you have any questions?
General Stevens, you said that there was an email that General Crouch sent to everyone in the DA's office instructing them not to discuss the case. Is that correct?
That's all right.
All right. Was there only one email or were there several emails?
I looked, I cannot recall if there were several. I do know that he had told others that, but I know that an email dated January the 23rd, just as a reminder, I think it actually says this is a reminder. So it had been more than once that he had notified everyone. But I could see one in January where he reminded the entire office not to discuss the case with me.
But you think that there may have been another one prior to that?
There may have been, yes, sir.
You joined the office at the beginning of December.
That's correct.
Is that correct?
Yes, sir.
Okay, all right. So, Mr. Stevens, you said that that files were moved away so that you could not access them. Is that correct?
Well, I would have never had this file, but they either belong to someone else, or for, say, for example, for any DUI-related file, my assistant Marley would move them to another prosecutor, and I do not have access to them.
Are you aware of General Sylvie getting responsibility for Mr. Hanser's file?
I believe that she may have been working that as a domestic grant person, but
Okay.
I do not know anything more from it.
You're located in the Ashland City office, correct?
That's correct.
So is General Sylvie, correct?
That's correct. That's where our primary offices are. We go between that and Dixon, but that's correct.
So based on that, the file for Mr. Hanser could physically be, so to speak, in the office in Ashland City.
I would have to speculate. I don't know where it is.
Do you share any kind of assistant in common with General Sylvie?
We have our own. I do not.
If you, who's in charge of you, Mr. Stevens, or General Stevens?
What do you mean by in charge, if I
Your
may ask?
supervisor?
That'd be Ray Crouch.
If he asked you to tell him information about the case, about Mr. Hanser's case, would you disclose anything?
Absolutely not.
And if you found out that if you had inadvertently disclosed something, would you advise Mr. Hanser that you had done so he could renew this motion?
I would renew it with you and, as the attorney of record, sir, not him specifically, but I would through you, sir.
I don't have any other questions, Your Honor.
Mr. Stevens, I did ask you if other people had been assigned to your cases as pro tem. Yeah, there we go. Were some of them just redistributed through the office?
I don't think we've had a pro tem on anything.
Correct. So I just wanted to clarify that. They were redistributed through the office?
That's my understanding from sitting in court, but they don't talk to me about it further than that.
Yeah, I used pro tem, so I just wanted to clarify that. Thank you.
All right, thank you. You may step down.
Thank you.
State, have any other proof?
Yes, Your Honor, I'd like to call Brooke Allen.
Do you solemnly swear or affirm the testimony you give in this case?
Miss Allen, can you state your name for the record?
My name is Brooke Allen.
And where are you employed?
I work at the 23rd Judicial District Attorney's Office.
How long have you been employed there?
I've worked with the DA's office here since 2011.
All right, Miss Allen, who is the lead counsel on Mr. Hanser's case?
That would be myself.
Okay. How long have you had this case on your caseload?
Since its inception in General Sessions Court, either 2022 or 2023. It's been quite some time,
Okay.
or maybe 2021. Since it started in General Sessions Court, I did the original preliminary hearing.
All right, and this is retained as one of your files, correct?
It is, yes.
Okay. Have you had any discussions with Mr. Stevens regarding this case?
No, ma'am, I have not.
Okay.
Not since he came to our office. Anyways.
I have no other questions, Your Honor.
Talbot?
Before, I think you changed offices recently, is that correct?
I did, yes. I now prosecute in Stewart County. My physical office is here in Charlotte.
In Charlotte.
Yes, but I travel to Stewart County and some in Houston County, but primarily Stewart County.
Is it also your understanding that Mr. General Stevens' office is in Ashland City?
Yes, sir.
Okay. And the strange question, the physical file, originally were you, before you moved to the Charlotte office so you could work in Stewart County, as the former domestic violence prosecutor, which General Sylvie took over, Were you located in Ashland City as well?
I was, yes, sir.
Now, when you left and you moved to the Charlotte office, did you take that file with you?
I did not. I have it today, and I will keep it in my office today. I will say if Miss Sylvia is going to be co-counsel on that case, though, she will need access to it, but she can come to my office in Charlotte and we can look at it together.
So is it fair to say that prior to this point, the file may have been with you in Charlotte or it may have been in Ashland City?
Yes.
Okay. And going forward, is it going to be in your office in Charlotte?
Yes, sir.
Okay. Are you aware of more than one email sent out to the district attorney's office in general regarding screening of Mr. Stevens from this case?
Yes, on December 10th of 2024, after Ms. Stack and Mr. Stevens were hired, sorry, Sylvie, I used her maiden name, I'm sorry. We got an email just talking about Mr. Stevens's cases and telling us not to talk about them and how we were going to distribute them and where the files would be kept. And then in January, we specifically received one about this case, just reiterating, do not discuss the case. And we have not discussed it with Mr. Stevens at all, other than saying that we're both showing up here today to testify regarding your motion.
If there were a disclosure from Mr. Stevens regarding General Stevens regarding any information from Mr. Hansard, would you tell me?
Absolutely.
All right. Thank you, General.
Redirect. Thank you, ma'am. You may step down. General Sylvia, you have any other proof? Any rebuttal proof? If you wish to make an argument, I'm going to take a moment I'm going to step off after you have finished your argument to reread your pleadings in this case. I've read them some time ago, but I want to refresh my memory on it and look at the rules of professional conduct before I make my ruling, but I'll certainly hear your argument.
Your Honor, it's simply that this is critically important. It's critically important that a fair trial occur, and the right remedy here is for another prosecutor to come in without any kind of risk of harm, risk to the defendant's confidences, to come in here and take over the case. That's the right answer. It's provided for by the law. And what I would emphasize for the court is that Mr. Hansard, the defendant, the accused, is not in a position to know whether confidences that he shared with his attorney have been disclosed. The only way he might find out would be in a trial setting, and then at that point, the damage is done. And therefore, Your Honor, we think that the risk here of potential disclosure is too high to allow the district attorney to continue, this office here, to continue to prosecute. So I'll leave it at that, Your Honor. Thank you.
Sylvia?
Your Honor, we are governed by the rules of professional responsibility in these cases. In hearing the proof today, one of the things that I would point out is that Ms. Brooke Allen has retained the case. Therefore, with not passing it along to me as the lead prosecutor for the case, there's been no need to really catch up on information. Ms. Allen was the original attorney. She kept it with herself. She has not transferred it to me. Therefore, there's been no need to really relearn a case file that would have changed between when Mr. Stevens was representing the defendant and when he was employed by our office. Our office has also done the appropriate Chinese wall, is the language used, to insulate the information and having any confidential information passed along. And in fact, from the testimony today, Mr. Stevens didn't even know who the lead counsel was on the case. So I would think that we, by our professional responsibilities, have upheld that, and that he did not even know who the lead prosecutor was on the case. So that would be proof to show that there's been no information passed along between counsels on this. Therefore, to our ethical responsibilities is ensuring that no confidences have been disclosed. We've been able to do that through the different procedures put in place with our office and shown by the proof today. As far as improprieties and things like that, a lot of them may be things based upon perception of the defendant. And as someone who has worked at the public defender's office, that's something we fight nonstop. So the only real reason for which I can see that there would be anything that would need to be changed would be upon the impropriety and the feelings of the defendant regarding any type of confidences that may be breached. As counsel for the state, we've always, and as being a former counsel of the public defender's office, sometimes even just who pays our salaries being the same person is something we have to fight nonstop in those different things with clients. So as far as anything ethically within the office, we have abided by all of those different procedures and policies that are put in place to insulate the passing of confidential information. It would be based solely on the propriety, the way it looks and the way it appears and the confidences of the defendant.
All right, as I indicated, I wanted to reread the defendant's motion, and the authorities have been cited in review of professional code of professional responsibility. So we'll take a short recess, allow me to do that, and I'll come back and give you my ruling. All right, I have reviewed again the pleadings, the motion that was filed in this case and some of the applicable law, and it is clear that, you know, a defendant has a right to ensure that he is, any information he's given his prior counsel is not being shared with the prosecution that's actually prosecuting him. And as was stated previously, the state is required to adhere to the rules of professional conduct the same as the defenses are, and the rules of professional conduct require that an attorney who represents an individual must keep that individual's confidences secret and confidential, no matter, even after they no longer represent the defendant. So that's a rule of professional conduct that requires that the lawyers not divulge any information that was given to them by the defendant. Whether Mr. Stevens was a member of the DA's office or whether he was in private practice, he would still be required to adhere to that same rule. So when we consider the fact that Mr. Stevens is clearly prohibited from engaging in the prosecution of his former client under the rules of professional conduct, that's not really much of an issue. The issue becomes whether or not his employment by the district attorney's office constitutes a disqualification or grounds for a disqualification for the entire office, including individuals who had no contact with Mr. Hansard in any capacity. And as has been pointed out, the rule regarding that is that if the district attorney's office is going to contest the disqualification, then they must prove by clear and convincing evidence that the challenged attorney has been sufficiently screened from the remainder of the staff and its work on the pending case, and that's under the State versus Clayburgh case that was cited by the defense. And in this case, unlike other cases that the court's familiar with, the state has proven, in this court's opinion, by clear and convincing evidence that Mr. Stevens has had no contact with the prosecution that Mr. Hansard is facing now that he is with the district attorney's office. It is indicated that at the time that he joined the office, he gave the District Attorney General Ray Crouch a list of his cases that he had involved with, including Mr. Hansard's case, and that emails were sent out to the staff to indicate that they were not to discuss anything about those cases, including Mr. Hansard's case, with Mr. Stevens. The indication was that there was at least one email, possibly two emails, that were circulated among the staff, and that Mr. Stevens' office is located in the Cheatham County office, whereas the lead prosecutor, General Allen, is located her office in the Charlotte office, and the testimony of Mr. Stevens and General Allen is that there's been absolutely no contact between them about this case, and that as a result of that, Mr. Stevens has been sufficiently screened from the remainder of the district attorney's office, and they're working on this case. I will put an order down that if there were to be some inadvertent disclosure of information, unintentional disclosure or anything else by Mr. Stevens, that information would be relayed to the defendant immediately to renew this motion. But at the present time, I find that there has been clear and convincing evidence that the state has sufficiently screened Mr. Stevens from any participation in the prosecution of Mr. Hansard, and therefore there would not be a grounds for the disqualification of the entire district attorney's office. Clearly, Mr. Stevens is disqualified, but not the entire office. That is the ruling of the court. Now, Mr. Hansard is set for trial, is that correct? When? May 29th, all right. Remains set for trial on that day. All right, we stand adjourned.